Members of the Committee on Civil Liberties, Justice, and Home Affairs of the European Parliament, greetings from Washington. Nations who believe the law constitutes the only true, nonviolent protection for freedom-loving people everywhere. It saddens me deeply to say that here in the United States, certain individuals played important roles in changing the U.S. Constitution in ways that have not been seen in a century or more. I refer to the Fourth Amendment that protects the privacy of all American citizens. While the Fourth Amendment demands that conditions of probable cause exist in order to demonstrate why a person's privacy rights should be violated, NSA slowly began to change the very meaning of that important language when the former director of NSA, Michael Hayden, stated that the operative language in the Fourth Amendment was not probable cause, but reasonable suspicion. Hayden made this distinction to free NSA from stringent prohibitions so that it could have a freer hand in judging what might be of intelligence interest in the wake of the tragic events of September 11th, 2001. The tentacles of NSA surveillance have been growing ever since, aided and abetted by a U.S. Congress, a Congress more eager to say yes in the name of national security than to perform its oversight duties in the name of the U.S. Constitution. Indeed, NSA's vague technical explanations only created further confusion, and Congress capitulated. When it was later revealed that the NSA was collecting information on Americans, NSA claimed the violation was accidental. However, we now know, thanks to Edward Snowden, that this assertion was patently false. When the news broke about NSA's invasion of privacy, two former and very highly respected directors of NSA, retired Army General William Odom and retired Vice Admiral Bobby Inman, commented sharply on the matter, and I both quote and paraphrase from the relevant news article. Should have been court-martialed was the judgment of the late General Bill Odom about Hayden, and President Bush should be impeached, added Odom with equal fury. Odom ruled out discussing the warrantless eavesdropping that had been revealed by the New York Times just a few weeks earlier. In a memorandum about the conversation, the reporter, Mr. Kenny, opined that Odom appeared so angry that he realized that if he started discussing the still classified issue, he would not be able to control himself. Why was General Odom so angry? Because he, like all uniformed officers of the military, took an oath to protect and defend the Constitution of the United States against all enemies, foreign and domestic. Because he took that oath seriously, and because, as the head of the National Security Agency, he did his best to ensure that all employees strictly observed NSA's first commandment, thou shalt not eavesdrop on Americans without a court warrant. Also disappointed was former NSA Director Admiral Bobby Ray Inman, who was one of the country's most highly respected senior managers of intelligence and an author of the Foreign Intelligence Surveillance Act of 1978. Inman took strong issue with Hayden's disregard of the law. And I quote, "There clearly was a line in the law which says you couldn't do this," said Inman. "You can't do anything that is not authorized." Inman spoke proudly of the earlier ethos at NSA, where it was deeply ingrained that you operate within the law, and you get the law changed if you need to. Hayden did not give a few PowerPoint slides that, with the help of today's technology, there is absolutely no need to balance security and liberty. There is no reason to sacrifice one iota. Surveillance involves two categories of information: metadata and content. Just take a brief moment to read a few of these examples. All right, could we have the metadata slide,
Mr.
please?
Wiebe, can I briefly interrupt? I think
yes,
it's the presentation. It's in front of you on your desk. Okay, so you can read along. Sorry.
Content would be the content of a Microsoft Word document, for example, or the body of an email, or the content of a telephone call. Those are examples of content. Whereas metadata are descriptors of content. For example, when you make a phone call, you use a telephone number. The telephone number that you are calling from and the recipient's phone number are examples of metadata. We call this kind of data addressing. Just like you have an email address, are typically metadata. Subject lines of emails, which describe content within the email, are metadata. All names of people's places and things are metadata. Account numbers, license plate numbers are metadata. Information describing photographs, the title of the photograph, how big the photograph is in pixels, inches, or centimeters. These are examples of metadata. If we could move, please, to the next view graph, which should be tracking Bob. Do we have the one that says, yeah, you had it, that's it. I want to give you examples of the threat. In this country, the United States, content may not be revealed without a court order. However, metadata is open to inspection by anyone according to U.S. law. The threat is that with metadata, every time a human being touches an electronic information system, they leave a marker, they leave an imprint. And those imprints are records that can be collected by those who wish to do electronic surveillance. And they can be aligned in time so that as you interface with information systems, the record can be placed against a calendar and a clock to see what you were doing when you interfaced with each of those electronic systems. Tracking Bob begins around 6 in the morning and ends at about 10:37 at night, and you can see the examples of the kinds of electronic transaction that he participates in and the records that it leaves. If we can move to the slide of illegal use of private information. It's entitled U.S. Drug Enforcement Agency Special Ops Division. This item is very new. You may have not seen it. The slides I have show two depictions of rules being followed by this organization. And what it essentially shows is that NSA information is being used by other U.S. government agencies to pursue their responsibilities. In this case, obviously, U.S. Drug Enforcement is interested in criminal activity involving the use or transmittal or selling of drugs and the like. The bothersome part of this, if you'll go to the second slide, illegal use of private information, the Special Operations Division is masking, covering up, if you will, the source of the information. Now, what this does for someone who has been indicted or prosecuted by the U.S. legal system is to remove any hope of facing one's accusers in a court of law, because the person will never find out that the information came from NSA. So this special division of DEA is told to cover up the source to make it look like the data came out of a typical investigation by law enforcement, perhaps the FBI or someone else. The authority for the mass collection of telephone metadata in the United States comes from a Supreme Court case, Smith versus Maryland, from 1979. I raise this case because it is upon this ruling that the entire U.S. surveillance structure is resting its case, demanding that it have free access to metadata of every sort. In this particular case, it involved a thief and his victim. The thief called his victim to harass her. The police installed a recording device that recorded the fact that he had made this phone call and used that evidence in court to prove that he was the committer of the crime and the person doing the harassment via electronic means. The government says the single use of metadata then allows the government to collect metadata en masse. This is a leap of logic that I frankly cannot share in, and most people with whom I speak cannot share in either. This matter has yet to be tested in court. In 1979, no judge could have envisioned that our whole world, our daily lives, would be permeated with the use of electronic devices, electronic transactions, toll road transponders, bank account transactions, credit card usage, and the like. The Fourth Amendment to the United States Constitution, and I read to you this important language because it's not long, but it's important for your deliberations. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is the standard. And I do not know European law, but I would assume that many of your own privacy laws read very criminal investigation, not just a guess or focus of analysis, 1 degree and 2 degrees of separation. Electronic transactions and computer systems are the threat to privacy. But I would argue the same tools are useful to guarantee privacy. Analysis can be conducted without ever breaking the rules governing the privacy of the individual. In the example on this particular slide, I have one person named John Doe, resides in Chula Vista, California. He is a known bad person. He's a criminal or a terrorist or something of that wrath. Are suspects. They have not been proven to be guilty of anything. Their information, those in yellow, the ones with him whom he is speaking or communicating with, are protected with encryption. Now, this technique allows them to be represented in this visual depiction. They're in a relationship, but there is no identifying data, just a unique one-up numbering system or some other nomenclature used to provide a unit in software. There is no need to expose intelligence analysts to the identifications of innocent people. In this example, content or some metadata activity indicates that are involved. Now, I want you to please understand, this does not necessarily mean that you convene literally a court. Many of the criteria that the court would define as probable cause for a business rule or a set of business rules, such that the court process and the decision could be made automatically, virtually in microseconds, certainly not longer than seconds, if this kind of technique were used. So this type of encrypted protect innocent people protects the innocent.
I
and that
apologize
is my
for
content.
interrupting you. Can you hear me? But